Very good morning to all you dear students. Today we are going to start with partnership, and in this partnership we'll be doing the various topics today. Topics to be covered today: definition of partnership, features of partnership, merits of partnership, limitations, types of partnership, and types of partners, partnership deed and registration. So these are the topics that we are going to cover today. Now students, in sole proprietorship, the problems that the sole proprietor was facing was limited capital. If you remember, sole proprietor, that is single businessman who was doing the business singly, that is individually. So he was facing certain problems like capital was very less, and his skills was also very limited, and he could not even share the risk of business with anyone. So in order to overcome this problem of the sole proprietor, one can do partnership. That is, one can join together with somebody else. That is, two or more individuals can come together, and with a certain business deed or agreement they can do business. With the result, the capital will be more, the skill in the business will be more, because there are more than one person, and the risk that is to be shared by only one person in sole proprietorship will now be shared in partnership by all the partners. Okay, now this topic, children, you will be doing it in accounts also, so it will be more clear with this the topic that we are going to discuss now. So what is partnership? The Indian Partnership Act 1932 defines partnership as the relation between persons who have agreed to share the profit of the business carried on by all, or any one of them acting for all. So in a partnership, children, persons join together and they share the profits and losses of the business, and it could be that one partner is doing the work for all the other partners, or all the partners are actively involved in the business. Okay, so this is the definition of partnership. Now let us come to the features of partnership. The first feature of partnership: formation. So how is it formed? This form of organization is governed by the Indian Partnership Act 1932, a legal agreement having terms and conditions governing relation among the partners, sharing of profit losses, and the manner of conducting the lawful business with the motive of earning profit is specified. So in simple terms, children, how is it formed? It is governed by which act? Indian Partnership Act 1932. And how is it formed? A legal agreement is made between the partners defining their relationship. What kind of a relationship is there amongst the partners? Who will take care of what kind of that is work? Okay. Then what kind of profits they will be sharing, and how will they share the losses? That is clarified. And not only this, what kind of a business they are doing, and it should be a lawful business, and it should be done with the motive of earning profit. This is how the partnership is being formed. That is, with the legal agreement it can be formed. Okay, so it is next is liability. The liability of the partners, children, is unlimited. That is, all the partners will be having unlimited liability. They can have jointly, all partners are responsible for all the debts of the business. Okay, so jointly all partners contribute in proportion to their share in business. Individually too, each partner is held responsible. Sometimes the third party can claim one particular partner for any kind of debt. In that case, the other partners will give the debt also That is, later on, the debt can be recovered from the other partners also in the amount of equivalent to the share in their business. So this is what is liability. That is, partners overall, they are having unlimited liability. In case of a loss, their personal property can be utilized to pay away the debts. Okay. Next is risk bearing. The partners bear the risk. Profits and losses are shared in the same proportion as agreed in partnership deed. So I told you the first feature of partnership is they should have a partnership deed or agreement. So in this only, in the partnership deed, it is specified that how much of profit each individual will be taking and how much of a loss will be borne by the partners. Now students, when the people or persons join a partnership, they come with a certain capital. Okay, they come with a certain capital. All the capital may be same, or sometimes the capital of some individuals, what they are contributing in the business is more, and some are contributing less. So as in how they contribute in the business, they take away the profit. If supposing a person is contributing more in partnership business, so definitely he will take away more profit from the business, and he will also bear more of loss in the business. Okay. So this is what is given in partnership deed very clearly, that how much is the contribution of each partner and how will they share the profit and losses. This is what is risk bearing. Okay. Next is decision making and control. Now decisions are generally taken with mutual consent. That is, all the partners must agree on whatever decisions are taken by the partners. So it is with mutual consent, mutual understanding, a decision is being made. The activities of partnership firm is managed jointly. So whoever are the partners, they manage the activities of the firm jointly. Okay, because they jointly own the business. Now continuity, death, insanity, retirement, insolvency of any partner can bring an end to partnership. However, the remaining partners can continue business with the new agreement. Now suppose if there are 4 partners in a business and one of the partner is he's going for retirement. Okay, he doesn't want to continue, he is going for retirement. In that case, partnership deed, what agreement they made earlier, has become null and void, or it will be that is replaced by a new agreement if the remaining partners want to continue the business. Okay. So in case of death, insanity, retirement of a partner, partnership comes to an end. However, the remaining partners can continue business with the new agreement. Okay. Next, number of partners, minimum 2 partners. According to the section 464 of the Companies Act 2013, maximum partnership can be 100. Now children, again according to the company's rule 2014, at present maximum number can be 50. Now these are 2 acts and rules that you have to be specific on. That is, minimum is clear, that is 2 should be minimum, but maximum varies from the section and from the rules. So section 464 of the Companies Act 2013, according to that, maximum number of partners should be 100, but according to the Companies Rule 2014, at present it can be 50. So you should know the acts and rules according to which what is maximum. Okay. Next, mutual agency. Now partners are helping each other, or they are mutually responsible for each other. Each partner is both the agent and the principal. Now, the partners are both the agent and the principal. That is, if he is representing other partners, so he becomes an agent and he binds them with his acts, and principal, as he too is bound by the acts of the other partners. Now, what is this, children? Mutual agency means whatever one partner does, okay, he is also binding with his act to the other partners. Supposing one partner goes and makes an agreement with a third party, so the other people in the partnership are also bound by his act. Therefore, he is an agent. He represents, each partner represents other partners and binds them with their acts, okay? And he is also the principal. Each partner is also the principal, as he too is bound by the acts of the other partners. Meaning to say, the responsibility of each and every partner is on the others, okay? That is, if they are doing a certain act, that will affect the others as well. So that is what is mutual agency. Each partner is responsible to each other, okay? So that is what is mutual agency, okay? Next topic, children. Merits. Ease of formation and closure. So the first merit of a partnership agreement is agreement between prospective partners and no compulsion with respect to registration. So it can be formed, and with just an agreement with the prospective partners, registration of partnership is not compulsory. They can register under the Companies Act, they may not register under the Companies Act. Balanced decision. Now, since there are more than one persons in the that is organization or the business, partners can oversee or different functions according to the area of expertise. Each partner can be expert in a certain area. So according to that expertise, he can see the different functions according to the area of expertise, which gives a balanced decision for the firm or the business, okay? Next, mutual fund. More funds. Since there are more than one individuals in the business, so capital contributed by number of partners, thus large funds compared to sole proprietorship. Next, sharing of risk. One of the merits of the partnership is that risk is not borne by one person, but it is shared by all the partners in the business. Next, secrecy. A partnership is not legally required to submit or publish accounts of business to the public, okay? So secrecy in partnership can be maintained because there is no legal formality telling that the accounts of the business, partnership business, should be published in public, okay? So every thing that they can do, okay, they can do their business secretly, or in the sense that they need not show their accounts to the others. So that is why secrecy can be maintained, okay? So these are the merits. Now coming to the limitations of partnership. Limitations means demerits of partnership. Unlimited resources. Partners liable to pay debts from personal property, okay? So this is unlimited liability, it should be, children. Sorry for this misprint here. It is unlimited liability. I'll just correct it now. Okay, I'll just correct it, 1 minute. This is unlimited liability, children. There's not resources. This is liability. Okay, so this is unlimited liability. Partners liable to pay debts from the personal property if the assets are not sufficient. Okay, so the thing is that each partner is having they are having the things. Just 1 minute, children. Okay, we start there. Unlimited liability of the partners. Partners liable to pay debts from personal property if business assets are not sufficient. So this is one demerit of partnership, that is partners have to, that is, give away their personal asset or property in case the business asset is not sufficient to pay away the loans. Okay, so next is limited resources. Contribution from the partners not sufficient to start large scale business. Now partners can be limited. Okay, so they are not very huge amount of people. They can be 2 in number, they can be 10 in number or 50. But if you want to go for a large scale business, you need a lot of resources. So it is not possible for partnership firms to go for large scale business because there is limited resources or limited funds. Next is possibility of conflict. Now children, since there are so many people in the business, due to difference of opinion, decision of one partner are binding on the others. Thus, sometimes when there is an unwise decision, this may result in financial loss and this may result in conflicts in business. So there is possibility of conflict because there are more than one persons in the business. Lack of continuity. As I told you earlier also, that partnership comes to an end with the death, insolvency of a partner. So if anything happens to any of the partners, if he is no more, or he is imprisoned, or he is insolvent, that is, he is having no money at all, the partnership will come to an end. A new partnership deed has to be made. So this is one limitation of partnership firm. Okay, so lack of continuity, it does not continue if anything happens to a particular partner. Next is lack of public confidence, as true financial report need not be published. So since the public is not knowing about the true financial status of the firm, therefore there is lack of public confidence. The public is not confident about such kind of partnership firms. Okay, so therefore they don't want to invest in such firms. That is the meaning of lack of public confidence. Next is, children, we will be doing types of partners. Now there are 6 types of partners we will be talking about. The first one, types of partners, how they deal in the partnership firm. Okay, so the first one, active partner, as the name suggests, so he is very active in the business, so contributes capital, participates in management, shares the profit and losses, and has unlimited liability. Okay, so who is an active partner? Who is very actively involved or participates in management. He shares the profit and losses and he bears all the liabilities of the business. He also contributes to the capital. Now sleeping partners, as the name suggests, that he is not participating in the management of the business. That is why he is sleeping. Okay, so contributes the capital, he gives the capital, does not participate in business, shares profit and losses, and has unlimited liability. So he is such a partner who is contributing capital, he is sharing the profit and losses, and has unlimited liability, but he does not participate in the management or in the business. He is not actively involved in the business. So that is why he is known as sleeping partner. Next is secret partner. Now he contributes capital, he shares the profit and losses, and has unlimited liability. That is, in case of a loss, he has to use his personal assets as well. But his association with the firm is unknown to the general public. So he is secretly in this partnership, okay, but he never reflects himself that he is a part of this partnership, okay, to the general public, okay, to the third party. The third party will never know that he is a partner of the business, okay. So he is a secret partner, okay. So active partner, who is actively involved, sleeping partner who does not participate in business, and secret partner whose association is unknown to the public, but he is contributing capital, sharing profit and losses, and has unlimited liability. Next is types of partners. Again, we are having three types again, children. Nominal partner, partner by estoppel, partner by holding. Now, who is a nominal partner? He does not contribute to the capital, does not share profit or losses, okay, does not take active part in the management, but allows his name, her name to be used by the firm, and is having unlimited liability as the third party knows him as a partner. Now once more, children, I am telling you who is a nominal partner. Supposing there is a person, a very popular person, nominal partner, okay. He is a very popular person. He is not a part of the firm, okay. He is not contributing capital, neither is he taking the shares, that is profit or losses from the business, but knowingly he is allowing his name, a popular person, maybe a film star, okay. He is allowing his name to be used by the firm. So in the eyes of the third party, okay, the people are knowing him that he is a part of this firm. So in this case, he will be having unlimited liability. So in case there is a loss, even he can be asked to pay away the debts of the firm, because he has allowed to use her name by the firm, okay. Next is partner by estoppel. A person is considered partner by estoppel if through her initiative and behavior gives an impression to others that she is a partner and has unlimited liability. Now what is partner by estoppel? Before I explain, I will just give you one example. Partner by estoppel. Supposing a friend, okay, of you are a partner in a firm, and your friend accompanies you for an agreement to be made with the third party, okay. So with your friend reflects with her behavior and with her initiative in the agreement as though she or he is the part of the partnership firm. So in this case, the third party has an impression with his or her behavior that this person is also a partner. So whenever there is a loss or any kind of disagreement or there is loss in the business, the third party can also claim this friend of yours who reflected herself with her behavior or himself with his behavior initiative that he is a partner. So he is having or she is having unlimited liability. Do you agree with this? Okay, children, once more I am telling. A person is considered partner by estoppel if through her initiative and behavior gives an impression to others that she is a partner, has unlimited liability. So you should just go through the example given in your book also, okay. Next, partner by holding. A person who allows himself to be represented as a partner of the firm. Now children, here the person is allowing himself, he is not allowing his name to be used. Like in nominal partner, I told you that the person is allowing his name to be used, but here the person is allowing himself, okay, he is allowing himself to be represented whenever the partners are going anywhere. So they are representing him as a partner. He is also part of this partnership. So in that case, this person, partner by holding, has unlimited liability. That is, if there is a loss, he is supposed to pay the loss as well, because he has allowed himself to be represented as a partner of the firm. But if he wants to save himself from this unlimited liability, he should deny and clarify his position immediately. Okay, then he will be protected from this unlimited liability. Okay, so this is what is partner by holding, a person who allows himself to be represented as a partner. So once more, children, nominal partner, he is allowing his name or her name to be used by the firm. Partner by estoppel, using with his behavior or initiative, gives an impression to the others that he is a partner. So he himself is giving an impression. Partner by holding, others are telling that he is a partner and he is allowing himself to be represented as a partner. So this is it, children, types of partners. Okay, now let us see types of partnership. What are the now here types of partner, children? You can see this, you can have this types of partner, it's there in your book. Okay, active partner, capital contributed, contributes capital, management, participates in management, shares in profit and losses, shares profit and loss, liability is unlimited. So based on the types of partnership, their difference has been given in this particular chart. Okay, so you can go through it in your book as well. Okay, so here active partner, sleeping partner, secret partner, nominal, partner by estoppel, partner by holding out, everything has been given. Okay, all of you. So next we'll just go through the next thing, types of partnership. Now we have talked earlier, we have talked about types of partners. Okay, now here we are talking about types of partnership deeds or partnership. Okay, so don't get confused, children. Now here types of partnership, classification on the basis of duration. So the first type of partnership will be based on duration. Partnership at will. So this is a type of partnership which can continue as long as the partners want to. That is, it is at the will of the partners to continue the business, or they can terminate the business whenever they want to with a particular notice. Okay, so this is what is partner at will. It is at the will to continue the partnership or to dissolve the partnership. Next is particular partnership. Partnership formed for completion of a particular project. Sometimes, children, when there is a construction of a building, construction of a dam, or construction of any kind of a road, etc., okay, then some people come together and they make a partnership. Okay, so this is what is particular partnership. They come together for a particular project. Okay, once the project is over, the partnership automatically comes to an end. So once completed, the partnership is dissolved. Okay, so this is classification on the basis of duration. Partnership at will, according to the partnership will, and partners will, okay, and partnership deed according to the particular project. Okay, next we are coming to classification on the basis of liability. Now liability, you already know what is liability, children. So general partnership, the partner enjoys right to participate in business. Their acts are binding on each other. The existence of the firm affected by death, insolvency, retirement of the partners. Liability of the partners is unlimited, just like we have been talking about earlier. That is what is a partnership. General partnership is what? Where all the partners are having unlimited liability. So that is what is general partnership. Liability of partners is unlimited. That is what is general partnership. Limited partnership here, children. liability of at least one partner is unlimited. So here all the partners are not having unlimited liability. One partner is having unlimited liability, whereas the rest have limited liability. Once more children, जनरल पार्टनरशिप में क्या होता है कि एवरी पार्टनर, सभी पार्टनर्स को अनलिमिटेड लाइबिलिटी होती है. That is, if there is a loss, they can have to use their personal property as well in general partnership. But what is limited partnership? Where only one person, at least one partner, is having unlimited liability, whereas the rest have limited liability. Like we had talked in joint Hindu family business, okay, where the karta was having unlimited liability and the rest of the people were having limited liability. Like that only in limited partnership, okay. So such a partnership not terminated by the death, insolvency of limited partners. So this kind of partnership is not dissolved if there is death, insolvency of a limited partner. So limited partner is having very less role here in this partnership. Limited partners do not enjoy the right of management, okay. So they don't even enjoy the right of management, and their acts are not a binding on other people. Like I told you, in general partnership, that is, each partner is responsible to the other. If the one partner goes and does one particular agreement, so the others are also bound by his act. But limited partners are not a binding for the other partners. Registration of this partnership is compulsory, children. So you must remember that registration of this particular partnership is compulsory, okay. So this is it about types of partnership. So there are two types of partnership we've talked about: classification on the basis of liability and classification on the basis of time, okay. So just look into it. Next we are having partnership deed. Now all this while we have been talking about the agreement between the partners. So what is the agreement between the partners known as? The agreement between the partners is known as partnership deed. The written agreement, what is the definition here? It is the written agreement that specifies the terms and conditions that govern the partnership is called partnership deed. So a partnership deed is a written agreement which tells about the terms and conditions of partnership, okay. And what can it include? It includes the name of the business, nature of business, kya business, what is the business is doing, duration, how long the business will be there, investment made by the partners, distribution of profit and losses amongst the partners, salaries and withdrawals by the partner. Will the partners will have a salary? Can they withdraw? Terms of admission, how will the one partner join a partnership firm and how will the person retire, okay. If at all there is a problem with a partner, how can he leave the partnership, or he can be expelled from the partnership. Then procedure for dissolving the partnership, solving any dispute, or preparation of accounts. Everything in details is mentioned in a partnership deed, okay. So what is a partnership deed? It is a written agreement that specifies the terms and condition that govern the partnership, okay. Next we will talk about registration. Children, I've talked about that it is not necessary to register in a partnership firm, okay. But what is the registration telling about, okay? According to the Partnership Act 1932, the partner may get registered with the registrar of firms of state in which the firm is situated. So according to this Partnership Act 1932, partners can get themselves registered with the registrar of firms in the place where they are situated. In case a firm does not register, it is deprived of many benefits, okay. If a firm is not registering itself, so certain privileges, certain benefits will not be given to the partnership firm. So the consequences of non-registration of a firm: a partner of an unregistered firm cannot file a case against the firm or other partners. So if a partner is there who is having a dispute with the firm in which he is, or he is having a dispute with the partners, he cannot file a case against the firm or other partners. Okay, so a partner of an unregistered firm cannot file a case against the firm. The firm cannot file, that is, an unregistered firm cannot file a suit or a case against the third party because it is not registered. So the firm is not going to file or cannot file a case against the third party. Okay, the firm cannot file a case against the partners. The firm also, the unregistered firm also, cannot file any case against the partners if they are in certain, that is, they are doing something which is not acceptable to the firm. Okay, so these are the that is benefits that they are deprived of if they are not registered under the Partnership Act 1932. So it is wise to register the firm, but it is just optional. Okay, so next, how can a firm register itself? Let us just see what is the procedure for registration. Submission of application with the following particulars. Okay, so the application has to be made, and what is the content of the application? Name of the firm, location of the firm, name of other places where the firm carries on the business, the date when each partner joins the firm, name and address of partners, duration of partners. The application should be signed by each partner. So with all these particulars, name of the firm, location, name of other places, date when every partner is joining, name and address of partners, duration of the partnership, and signed by all partners should be submitted, okay, to the registrar. And certain depositing fees, that is, deposit of required fees should be there. Some fees is required to be deposited, and then the registrar, after approval, it will be given to the registrar, okay, of firms, and the registrar after approval will make entry in the register of firms, and he will issue a certificate of registration. So once all the particulars are submitted and the registrar is approving it, so the firm's name will be registered in register of firms, okay. And what will the firm get? The firm will get a certificate, that is the certificate of registration, okay. So thank you to all of you, okay. So this is it, children. We'll be finishing off with this today. So it is a long slide. Please go through it again and again if you want to hear it, okay. So bit by bit, just go into the slide, okay, then you will get it better, okay. Like go into the definition, merits, demerits first, okay, and then you go into the types of partners and types of partnership, and then come to the that is registration, and that is partnership deed. So this is the three things, three ways you will split this video into, and you should see into your books as well, okay. So read into your books as well, okay. So thank you to all of you. Have a nice day.